Hello everyone, welcome back to my channel. For today's video, we're going to be looking at Meghan Markle's success against associated newspapers. Now, we've already discussed the facts and the background and the causes of action, the relief sought, all the preliminary things, what's being argued by both sides in a previous video. So if you haven't watched that already, please watch that first if you don't know anything about the case before watching this one. I also want to say that I'm going to try this new thing where I start to split my longer videos into two different parts rather than one big block of a video. If you're familiar with my content, then you'll know that I easily go over the 30-minute mark with my videos, and it is actually quite tedious to film and edit these long videos. And also, according to my analytics, the viewers do appreciate a shorter video, which of course is quite usual for YouTube. So for this video, we're going to be looking at the portion of the judgment that deals with her privacy claim. And for the next video, we'll focus on copyright as well as discussing my personal take on the judgment. Because the video is in two parts, I do urge you to wait for part 2 to come out before asking me, well, what about this and what about that? Why didn't you talk about that? So I will be hitting, hopefully, every single relevant point to talk about, including what's next for this case, because it's actually not over with regards to copyright, and also whether the opposing side wishes to appeal. So we will be discussing that in due time. From the previous video, you'll remember that Meghan has applied for summary judgment against associated newspapers. That wasn't even a long time ago. That was around January. So this was a relatively quick judgment. I do explain what a summary judgment is in my last video. So the focus of this video will be the judgment itself. Meghan has applied for summary judgment because it is her case that the other side, the defendant, associated newspapers, has no viable defense. So they have no real prospect of successfully defending the claim. And so the judge's main focus in determining whether summary judgment should be granted is whether it is realistic or fanciful to suppose the claims might fail at trial. So is Meghan right in saying that the defense has no real prospect of success? Now, of course, we all know that she ended up being right, but let's have a look into the reasons for the judge's decision. Now, in the last video, we discussed the elements of all the causes of action, including this one that we're going to look at right now, invasion of privacy. The two elements that must be satisfied are, firstly, did the claimant, Ms. Markle, have a reasonable expectation of privacy in this instance? And this is particularly with regards to Article 8 of the European Convention on Human Rights. And I also want to bring your attention once again, as I did in the last video, to the term correspondence that is specifically mentioned in Article 8. And a letter to your father, of course, is a form of correspondence within a family context. Now, the second element is a balancing act between freedom of expression, as stipulated by Article 10 on the one hand, and the right to privacy, Article 8 on the other. And as you all know by now, the defendant is claiming freedom of expression as per Article 10. Now, in my last video, I stated that personally, I think that she satisfies both of these elements, and the judge agreed. It's also worth noting that the judge referred to the editor's code of conduct, which the defendant is bound by in the UK. Specifically, Clause 3 of that code mirrors Article 8 of the Convention. So it provides that interferences with privacy must be justified in the public interest. And editors are expected to demonstrate this and to show and explain how they reasonably believed that publication would serve and be proportionate to the public interest. All right, we know that the judge found that both of these elements were satisfied. Let's look into why he thought so. He first points out that by the time the article was published, none of the detailed contents of the letter were available in the public domain before publication by the defendant. And this is very important because they're arguing that it was already public knowledge. The article in People magazine hinted about the existence of the letter, and so it wasn't anything new that we disclosed to the world. Now, that argument failed for multiple reasons. Firstly, The judge very aptly pointed out that the defendant's subsidiaries, so the Mail Online, took pride in the fact that they revealed the contents of the letter for the first time. So they've shot themselves in the foot, really, because they're arguing it was already out there, but at the same time, when they published it, they acknowledged and almost showed off that they were the first to reveal any details of the letter. With regards to the People magazine article that they keep referring to, the letter's existence was mentioned, but none of its detailed contents. So the judge is saying that, sure, the People magazine article may have hinted or even expressly talked about the existence of this letter. None of the actual contents of the letter were ever disclosed. The second argument that the defendants put forth is that Meghan is a public figure. And so she doesn't really have a reasonable expectation of privacy. Again, I disagreed with this in my last video. The judge's response to that is, while she is indeed a public figure and must accept a degree of intrusion that others wouldn't have to bear, it has been long established that a public figure does not, simply by joining a select group, give up her right to a private life or open up every aspect of her private and family life or correspondence to examination in the press. So just because she married into the royal family and became a public figure, that doesn't automatically remove any right to privacy on her part. It is quite a ridiculous argument to put forth, in my opinion. So they're basically saying if you dare become a public figure, then all bets are off. We can publish anything, absolutely anything about you. So I'm really glad that the judge didn't agree with this one either, because that would have set a very dangerous precedent. Another finding made by the judge, which we alluded to earlier in this video and I talked about in my last video as well, is that term correspondence and a family correspondence specifically. So the judge really focused on the fact that the letter was clearly of an intimate nature. It wasn't a business letter, for example. And then to go even further, the judge pointed out that the Mail itself stated in the publication that the letters were of a deeply personal nature, referring to it as Meghan's private letter to her father, in which she pours out her heart to him and is deeply personal. These are all the Mail's words, not Meghan's. So again, they shot themselves in the foot because they themselves have described how personal and private the letter is in its nature. It's really ironic how these catchphrases, world exclusive, deeply personal, all these words they use to make a headline and to grab people's attention, ended up being their demise at the end. The judge stated the laws pertaining to the privacy of such letters, and he noted that the most commonly accepted authorities in case law acknowledge that letters of such a nature are prime candidates for protection. So one's correspondence with others is presumptively private in nature. A further argument made by the defendant is that Thomas Markle, Meghan's father, has every right to comment on the letter because it involved him. No one ever disputed that. And no one ever said Thomas Markle doesn't have that right. In fact, I stressed in my last video that he indeed does have that right. But I also said that he didn't have to go all the way and publish this private letter. He could have responded in any other way by giving interviews as he usually does, summarizing, paraphrasing his position, rather than actually publishing excerpts of the letter. And again, the judge noted the same thing in his judgment. Specifically, the judge stated that respecting Ms. Markle's right to privacy doesn't significantly impinge on Mr. Markle's entitlement to give his own account of events. It only restricts his right to use the contents of the unpublished letter as a means of doing so. Now, a major argument put forth by the defendant was that Ms. Markle should have known, based on her father's past behavior, that he will leak the letter. The judge rejected this argument as well. He stated that this doesn't deprive Ms. Markle of a reasonable expectation that her father would keep her letter to him private. A person's rights against another are not defeated by the prospect that those rights may be ignored or violated. A high level of risk-taking might be capable of affecting the assessment of damages, but it doesn't excuse an intrusion into privacy. So this argument could have an impact on Meghan's damages claim. So it could reduce the amount that she can successfully claim as a result of this breach. But it doesn't defeat the cause of action itself. I'm really glad this one failed as well, because once again, it could really set a very dangerous precedent if it was accepted. A minor argument that I didn't even mention in my last video because I actually found it so ridiculous is that publication was lawful at all times in the US. So basically US laws would allow for this to happen. And so therefore it should also be lawful here in the UK. Once again, it failed. It's ridiculous. The judge very aptly stated that we're in the UK here. We're dealing with English law, not US law. So whatever is legal over there doesn't mean that it's okay over here. Now, a lot of you mentioned this book that was co-written by Omid Scobie, I think that's how you pronounce his name, in which the letter was mentioned, and I believe excerpts of the letter were also mentioned. And many of you stated in the comments of my last video that because that happened, Meghan has no right to claim that the mail invaded her privacy and infringed her copyright, because the letters were already available in the public domain in that book. That wasn't the case. That book was published in August of 2020, which is after the publication of the letter by the defendant. According to the witness statement of Omid Scobie, the book referenced excerpts of the letter that were already published by the defendant prior. And without going into more detail, because the judge actually goes and makes comparisons of the excerpts in the book and the excerpts in the letter, which did in fact turn out to be quite identical. So that really contributed to Omid Scobie's credibility in the eyes of the judge, and he found that to be a very plausible argument. So we're still dealing with the fact that, forget the book, forget People magazine, the defendant was the first to publish the excerpts of the letter. Another quite weak argument, in my opinion, that was put forth by the defendant was that because of the handwriting and how careful it was and how neat it was, and because of the fact that Miss Markle kept a copy of the letter, they argued that both of these factors mean that she intended to share it with the public at some point, with the motive being to improve her self-image. This is incredibly weak on many points, and the judge points this out. First of all, he noted that Meghan is a trained calligraphist. And I actually found out during my research that she used to run a calligraphy business on the side when she was a struggling Hollywood actress before she landed her main role in Suits. And that's why the handwriting in the letter, as pointed out by the judge, was so careful and so particular. For whatever reason, she wrote the letter in her calligraphy handwriting, which she is known for doing. She even, whenever she makes public appearances and she signs the guest book or whatever, or makes a note, if you see photos of these appearances with Harry, she always writes in that very quite beautiful calligraphy style handwriting. So to argue that she did this on purpose to show it off to the world is quite far-fetched and difficult to prove, specifically because she is a trained calligraphist. And then the judge pointed out that keeping a copy of an important letter, one would assume that it is quite important to her, this letter that she wrote to her father, doesn't mean she wants to share it with the public. She just wants to have a copy of it, which I see nothing wrong with. If anything, maybe she held on to a copy because she knew her father and wanted a backup of the original, because if he had the only copy in existence, how could she rebut him? So it was a smart move on her part. The judge goes on to point out that the modern position in the law of confidentiality is that an intention to publish, so an intention, is not inconsistent with maintaining a right of confidentiality until the intended publication takes place. So even if Meghan intended, I'm sorry, by the way, I know I keep calling her Miss Markle and Meghan. I'm trying to be consistent, but sometimes I'm just really into my arguments and I just forget. So the judge is saying that even if she did intend on sharing it at some point in the future, that still does not deprive her of her right to keep this letter private and confidential. Intention to do something, without actually going ahead and doing it is simply not enough according to the law. Now, of course, this is only with regards to this case. I don't want people thinking that if you intend on committing a crime, for example, you can get away with it as long as you don't do it, because the various crimes of conspiracy to commit, intention, planning, all of these things can be crimes in and of themselves. So I'm not saying that intention is always insufficient. We're dealing with a civil case here, not a criminal one. Criminal cases always have a much higher standard. So in conclusion, with regards to the first element, the judge found that the claimant, Miss Markle, would be bound to win at trial on this issue. It is fanciful to think otherwise. There is nothing in the defense that could lead the court to find for the defendant on this part of the case. So Meghan did have a reasonable expectation of privacy with regards to this correspondence, and there was no real prospect of successfully defending that claim. The second limb is the balancing act. Freedom of expression, Article 10, versus the right to privacy in Article 8. And this also includes a consideration of the editor's code of conduct, in which this balancing act was also talked about, less so in terms of freedom of expression and more so in terms of public interest. So public interest versus the right to privacy. Now, we've already talked about how the judge rejected the notion that Miss Markle's public status automatically deprives her of any right to privacy. With regards to public interest, the judge stated that it is a firmly established principle, which this court must take into account, that articles aimed solely at satisfying the curiosity of a particular readership regarding the details of a person's private life, however well known that person might be, cannot be deemed to contribute to any debate of general interest in society. So they argued it's in the public interest for people to know what kind of a person Miss Markle is, and the judge rejected this because it's tabloid gossip. How will society benefit in any way from reading the contents of a private letter sent from a daughter to her father? Now, if she was talking about a crime, if it was a conspiracy to commit something, if it was very damning and put someone else's life in danger, that's an entirely different story. Of course, a public interest would apply in that case. But when it's personal matters, purely dealing with the relationship between a daughter and her father, how is it anyone else's business to know what the letter was about? The judge went on to say that the defendant's arguments provide no foundation for a conclusion that the publication complained of served any purpose other than satisfying public curiosity about the claimant, or that it was even capable of making any contribution to a debate of public or general interest. I think there's no need to further talk about this point. It's quite clear. We all have a right to privacy. So does Ms. Markle. Now, I've talked about in the last video about how the defendant put forth that in this balancing act, the court should consider the competing rights of other people, being Mr. Markle specifically in this case. So his right to express himself, his right to correct the record and to correct his image in the public. The judge found this argument entirely hopeless. He stated that there is no authority to support the view that the mere fact that a person believes his portrayal is untrue is enough to justify a reply. That cannot be the law. It would legitimize replies which were in fact false and unwarranted, as might well be the position here. Moreover, the notion that the use of the letter is legitimate or even relevant to bolster such a reply from Mr. Markle is not just unexplained, it's unsustainable. It is fanciful to suppose that the court would find the disclosure of the contents of the letter necessary or proportionate on the basis set out here. Self-defense is only lawful if it's proportionate to the threat or the perceived threat or the actual infliction of harm committed against a person. So if you come at me with your fist and you want to punch me and I pull out a gun and shoot you, that's not proportionate. But here essentially the court is saying that if you want to correct your public image, and we talked about this already, go ahead and do so. Talk about it, give interviews. But to go and publish the letter was excessive and disproportionate. If Meghan had published parts of a letter he wrote, for example, to her, then arguably it would be Thomas Markle's right to publish her letter to him in response. But we all know that that wasn't the case. And it wasn't even published in direct response to something Miss Markle said or did herself. It was in response to this People magazine article where her friends were defending her, which, as far as we know, Meghan did not authorize her friends to speak on her behalf. Now, whether that's true or not, I don't know. And quite frankly, it's irrelevant. And you know why it's irrelevant? Because even if Meghan authorized her friends to talk and say what they said on the article, that still wasn't bad enough for him to respond in the way that he did. So the defendant and Mr. Markle argued that the People magazine article was vastly inaccurate. But the judge found that they considerably overstated this inaccuracy. If anything, the article wasn't an attack on Mr. Markle, but rather a misdescription of Meghan's behavior. So self-defense has little or nothing to do with this justification. Now, of course, the judge read the People magazine article. It's also worth noting that he read the full version of Meghan's letter to her father. And so obviously he has more insight than any of us do because he has the full letter. And so he is in a qualified position to state that the People magazine article was simply a misdescription of the letter, but not necessarily an attack on Mr. Markle himself. It is worth noting that the judge did agree with the defendant's description of the letter, which is that it was an admonishment of Mr. Markle and his behavior in the public. But as I stated in my last video, even if it was an admonishment, that doesn't in and of itself change anything with regards to the private nature of the letter. So I pointed out this admonishment thing because the judge isn't completely siding with Miss Markle on every single point. He thinks she was scolding her father. In the letter, though, not the People magazine article. Mr. Markle's problem was the People magazine article. So in summary, the judge found that Miss Markle had a reasonable expectation of privacy with regards to this letter, and taken as a whole, the disclosure of the letter was manifestly excessive and hence unlawful. There is no prospect that a different judgment would be reached after a trial. The interference with freedom of expression is a necessary and proportionate means of pursuing the legitimate aim of protecting the claimant's privacy. And that brings us to an end with regards to this cause of action. Now, the next cause of action is copyright, which is not fully resolved, as I said when I opened the video. Another aspect is the GDPR, so the data protection regulation that applies to the EU and its member states. That too was unresolved in this hearing and therefore was not mentioned in this judgment. So we're going to have to wait for a further decision with regards to that cause of action. If you don't know what I'm talking about, please watch the first video that I released on this topic. All right, so that's it for this video. Stay tuned for part 2, in which we'll discuss copyright and any other outstanding topics pertinent to this case that we haven't covered in part 1. I do also want to say, and I have said this on Twitter, I am not biased. I am not a fan of Meghan Markle. In fact, I virtually know nothing about her, and I definitely didn't know anything about her before she was announced as Harry's fiance. I didn't even know they were dating prior to that. So this is not about siding with Meghan Markle. As I always say, even with regards to the other cases that I cover, this is about what's right and what's wrong. You can put any person in Miss Markle's place. You can put anyone in Johnny's place. You can put anyone in Michael Jackson's place. I will still argue the same points because it's not about the person. It's about what was done to them. If it's not right, I don't care who they are. I'm not going to simply side against them because they have such a bad public image, as is the case with Miss Markle. I know that it's very popular to hate her, and it was actually very clear in the comment section of my video and also on Twitter that she is a very hated individual. I don't hate her. I don't have any strong feelings about her. I think that the media treats her incredibly unfairly, and from what I have seen of her, she seems to be quite a pleasant person. I don't see the vile, narcissistic person that the media insists that she is, particularly, of course, the UK tabloids. But that doesn't mean I like her and I'm biased and anything in her favor is what I am vying for. Absolutely not. Also, I did actually find out just today, which is the 15th of February, that she is pregnant with her second child. Now, of course, that doesn't really matter, and I don't care about these things. Wish them all the best. But I do wonder whether that was why she initially applied for an adjournment of the trial to autumn of this year, because it was meant to be heard earlier. But due to personal reasons, they said at the time, she sought an adjournment. Now, of course, that all doesn't matter anymore because she was successful in her application for a summary judgment. Other than that, do let me know what you think in the comments. Please try to be reasonable when assessing this case. Put yourselves in her shoes. Don't simply view her as Meghan Markle, the woman everyone loves to hate. Try to approach these cases from an objective point of view. Don't let your emotions and your hatred or your anger color your opinions. And before I forget, I do want to thank everyone for all your incredibly positive reviews on the latest music video that I put up, Loyalty's Dead. For those of you who didn't know that I am a musician and the two other songs on my channel, Blue Eyes and Once a Liar, are me. Now you know. I was actually a musician since I was 11, so it's definitely my first and true passion and something that I am very serious about, as I'm sure you can see in my content pertaining to my music videos. All right, that's it. Please try to be nice in the comments. Thank you all so much for watching. A very special thank you to all my patrons. Stay safe, and I'll catch you in a future video.